Hi, hello everybody. Greetings everyone. Welcome to the 18th International Conference on Artificial Intelligence and Law. My name is Lara Rocha Garcia, and this is the 5th panel of the third day of the event. Also, in the name of the International Conference on Artificial Intelligence and Law organization, I'd like to thank you, our platinum sponsors, JUS Brazil and Albert Einstein Israeli Hospital, and our gold sponsors, Logarithms, Legal Code, and PG Lawyers, and our silver sponsors, Urbano Vitalino Lawyers, Obsubun Lawyers, and Oasis Open. First, I'd like to mention our platinum sponsors. JUS Brazil is currently the #1 law and government website worldwide that makes high-value legal information easy and quick to access. Albert Einstein Israeli Hospital, our other platinum sponsor, is one of the best-known health units in Brazil and Latin America that is referenced in treatments with state-of-the-art technology and humanized care, expanding its borders with social responsibility actions, teaching and researching activities. Now, I would like to introduce Mr. Daniel Ho and Mr. Matthias Grabmeier, who will present the full paper, Context-Aware Legal Citation Recommendation Using Deep Learning. Daniel Ho is the William Benjamin Scott and Luna M. Scott Professor of Law at Stanford Law School, Professor of Political Science and Senior Fellow at Stanford Institute for Economic Policy Research. He is also Associate Director of the Stanford Institute for Human-Centered Artificial Intelligence, Faculty Fellow at the Center for Advanced Study in the Behavioral Sciences, and is Director of the Regulation, Evolution, and Governance Lab, RegLab. He received his JD from Yale Law School and PhD from Harvard University, and clerked for Judge Stephen F. Williams on the U.S. Court of Appeals, District of Columbus Circuit, who previously served as president for the Society of Empirical Legal Studies and co-editor of the Journal of Law, Economics, and Organization. Matthias Grabmeier is a tenure-track assistant professor of legal tech in the Department of Informatics at the Technical University of Munich, Germany. Before, he worked as a legal data scientist at the German legal informatics company Sync, and spent 4 researching and teaching years at Carnegie Mellon University's Language Technology Institute. He obtained a diploma in law from the University of Augsburg, Germany, as well as an LLM and PhD from the University of Pittsburgh. Mr. Daniel Ho and Mr. Matthias Grabmeier, you have 20 minutes of speech. Afterwards, we will move on the questions. The stage is yours.
Thank you so much, Laura, for that introduction. And we're really delighted to be able to share this work with everyone at such an amazing venue. This is joint work with students at Carnegie Mellon, Zahan Charles, Mengxiu, and Hongyi, as well as a JD PhD student here at Stanford, Mark Krass. And we're really sort of excited to share this with you. The motivation for this work is the well-documented problems of mass adjudication. A less known fact about the US judicial system is that government agencies adjudicate far more cases than all the federal courts combined. Even a single agency like the Social Security Administration hears 500,000 cases annually. And that has led to really profound challenges in the administration of justice, where going back to close to 50 years to Jerry Mashaw's work, we know that the identity of who the administrative law judge is matters greatly, and in his view, even more than the facts of the case, such that award rates plotted here can range between close to 0% to 100%, depending on the assignment of the administrative law judge, leading some scholars to decry this as a form of disability roulette. This is what the file room of a recent mass adjudicatory agency in the American system, the Board of Veterans Appeals, that we're going to study here, looked like as of a number of years ago. And so that came with really profound challenges, both in terms of the caseload, wait times for veterans exceeding 5 years from the time a notice of disagreement, a notice of appeal is filed until resolution. And here from some data that James Ridgway, who used to be at the BVA, presented, the result of this kind of increased caseload was that staff attorneys had about 10 to 15 seconds per page of the record, and veterans law judges with larger staff reporting to them had about 45 to 60 minutes for review per written appeal, such that in 2018, a survey revealed that 90% of the staff attorneys reported having inadequate time to review the record. And that is really the kind of motivation for the kind of work we're doing here. It seems to have, where we're going to look at these BVA decision texts, so all texts from 1998 to 2017, about 750,000 decisions, and we're going to focus on single issue cases, and we're going to bring in some metadata from the internal system, and also use the Harvard Case Law Access Project to combine and really figure out whether there are ways in which we can use advances in natural language processing to really help improve the accuracy and consistency of this process. For those of you who are wondering what VACL stands for, it's the internal database that the Board of Veterans Appeals actually uses to move cases along. And it literally stands for the Veterans Appeals Control object locator system, because it's literally the system that was used to try to figure out which room a file was located in. And so we've got basic information about claims and diseases spanning the years 2009 to 2017, and close to 300 identifiers for veterans law judges. And the basic way we're going to try to tackle this is to really see whether we can develop methods for better citation and application of precedent during opinion drafting, given the quality and consistency challenges in mass adjudication. So the kind of hypothesis, whether we can predict, build an ML system that really recommends citations that are specific to a case context. A little bit of motivation here is if you look at the existing kind of trends in large language models, if you turn to a model like GPT-2, you can prompt it with a statement like the following: as the preponderance of the evidence is against the claim, the benefit of the doubt doctrine is not applicable and the claim must be denied. And GPT-2 actually returns what look like pretty sensible sets of citations here that might be seen to support this statement. It respects the order of authorities as spelled out in the Blue Book. These look like roughly properly formatted sort of citations. The only small problem is these are citations to cases that don't actually exist. So there are still major advances that have to be made here. The actual kind of target would be Gilbert versus Derwinski for this particular statement about the benefit of the doubt doctrine. Similarly, another kind of example here would be a statement about material evidence. Material evidence means evidence that by itself or when considered with previous evidence of record related to an unestablished fact necessary to substantiate the claim. The kind of typical citation would be to the Code of Federal Regulations. And with that motivation, I'll turn it over to Matthias to talk about our technical approach to really solve this challenge.
Unmuting myself. Okay, thank you very much, Dan. I will present our technical approach now. And the first thing we do in our pipeline, so again, thank you for having us at this wonderful conference. It's a pleasure to be here. I'll present the technical approach. I hope my microphone's working. The first thing we do in this project, in its technical pipeline, is to pre-process the BVA decisions in our corpus. We do that using a comprehensive set of regular expression extractors that pull out citations to cases, the United States Code and the Code of Federal Regulations. We mask those citations in the text and forward the decisions with the masked citations to our tokenizer stage. Parallel to that, we take the raw citations that were extracted and apply a normalization procedure that resolves those citations to either the case law access metadata corpus, specifically the vet app and F3rd reporter. We also normalize citations to the United States Code and the CFR in a way that I'll explain in a moment, and hence assemble a comprehensive normalized citation vocabulary from which we draw the relevant citations and merge the decision back after having been, after tokenization. Okay. Okay, I'm getting a message that the video doesn't work. So
I see you now.
Okay, we're seeing. Okay, sorry. I'll just walk back to, thank you for the pointer. This is the graph I was supposed to be showing. So again, decisions come in, we extract citations, mask them, feed things into the tokenizer, in parallel, take the raw citations, apply our normalization procedure, and remerge those citations. Thank you for raising my awareness to this issue. To illustrate the citation normalization, we take case citations which we identify by the reporter name, the volume, and the page number, and we use case law access metadata corpus to identify a unique ID that we can resolve this case to, and all versions of referring to, say, Dekmatich v. Brown, are then resolved to this lemma. Citations to the CFR and the United States Code are decomposed into the prefix and the tail, where the tail is then segmented into individual elements. And so a full citation string becomes a list of normalized atomic citations. And using this procedure, we're able to boil down the 97,000 unique citations in our training data to about 4,300. 4,000 of which are normalized according to this distribution. We get a total normalization coverage of about 98.5% of the 5 million instances in our training data, which we think is fairly good. So the formal definition of our task is then to take a tokenized context segment from our decision, which may include already some special tokens such as paragraph breaks or other citations, and to predict in a delimited forecast window, the index of the next citation in theirs, in this case here, 132. As Dan has mentioned, this could be considered a text generation task. However, as we've seen in the example before, it's hard to generate full citation strings. So we treat this as a classification task, which is the slightly easier task to make incremental progress with. Of course, citation recommendation is a well-studied problem. For general and scientific literature recommendations, predominant approaches are collaborative filtering, graph-based and context-based models. There's also some work being done in the legal AI sphere, specifically often in conjunction with legal citation networks. There's also proprietary systems such as case text parallel search or Thomson Reuters quick check, etc. I'll refer you to the paper for details, but I do want to acknowledge the basic collaborative filtering and context-based approaches because this is what we are using in our model. As a baseline, we use a collaborative filtering model. So instead of one receiving, being a user and receiving, say, movie recommendations on Netflix, you are opinions here get recommended citations. To do that, we treat a case opinion as a bag of citations, which allows us to compute distance measures to other cases. And then additional recommendations are scored according to this distance metric. And the metadata Dan has explained is added using is aggregated using an SVM ranking module from which we then predict the citations. Our next model then adds textual context to it by representing the text preceding the citations as a bag of words in a TF-IDF vectorization, and we recommend citations by computing similarity from a query context to the contexts in the training data and the citations that follow them. Again, metadata is added to the model via as part of an input to an SVM ranking module. Our first full-blown NLP model is a bi-LSTM, which reads the citation context back and forth and gets its encoding concatenated with the metadata and fed into a classification head, which then predicts into the vocabulary size. Similarly, we take a pre-trained English pre-trained Roberta model, which is a stacked transformer architecture, which encodes the context, concatenates the encoding with the case metadata again, and feeds it into a classification head, which projects into the vocabulary size. This brings us to our results. So we evaluate recall at 1, 5, and 20. So the probability that our model predicts the correct citation in the top 1, top 5, and top 20 site recommendations. And our primary results are in the neural models are for context sizes of 256 and forecast sizes of 128 tokens. The first thing we see here is that our neural models, of course, unsurprisingly outperform our non-NLP models with recall at 1 in the mid-60s, recall at 5 in the lower 80s, and recall at 20 in the low 90s. We also observe that the Roberta model, despite being pre-trained, only does consistently perform better than the BI-LSTM model, but only by at most 1%, and usually within ±2 standard deviations across our 6 test folds. So pre-training, the benefits of pre-training are marginal here. What's also partially not shown here, and I would refer you to the paper for that, is that there is no, the benefit of metadata influences training, but there's no consistent benefit in adding it in the different architectures. This is an area where we intend to conduct research in the future. And again, the details of the results that we observed are in the paper. If we take our best performing Roberta model and we run it over time, we observe that the model performs equally for case regulation, equally well for case regulation and statute citations, and also fairly stable across time, with this little oscillation down here, we conjecture being due to a change in veterans law. We also observe the decline of the model performance as the distance to the citation in the forecast window increases. This decline is, of course, more sharp for recall at 1 than it is for recall at 5 and recall at 20. Still, so we do see some evidence here that the model is probably engaging in a fair amount of memorization of textual context, specifically for verbal and verbatim quotations of the sources before the occurrence of the actual citation. Still, the fairly gradual decline of recall at 5, which is sort of we consider the most representative use case scenario, suggests to us that the model does learn some amount of long distance patterns, and that it's a promising approach, technical approach, to treat citation recommendation, at least in part, as a classification problem and benefit from supervision signal, rather than treating it just as a pure encoding similarity retrieval retrieval approach. Finally, we did an ablation experiment, and Mark Grass produced this graph here. First, please look at the right half here, where we compare models that predict 64 tokens into the future and models that predict 128 tokens into the future. So the upper quadrant is easy and the lower quadrant is hard. And we can see that if we give the model more context, larger context as we move to the right, the increased slope here shows us that the model performs better the more context we give it. And for the easier task up here, the more flat slope here shows us that for predicting 64 tokens ahead, giving the system more context doesn't help as much. The only other piece of information here before I hand it back to Dan is if you compare this to the left half of the model, of this graph, where we graph models that do not have access to metadata, we notice that if you are in the hardest task, which is you predict 128 tokens from a short context, actually, if you give the system metadata, so we're comparing these two spots, performance improves a bit, which means that if the model has to predict very far in advance and has little context, it may actually benefit from some metadata, but this benefit disappears more or less the more context you give it. And with that, I will hand it back over to Dan.
Great. if you just go to the next slide, Matthias. So we think we've shown the utility of this kind of a context-based citation recommendation system. And it's particularly notable that in the kind of more sophisticated models, the benefits to adding metadata were really kind of marginal. There are, of course, lots of other really interesting legal implications when we think about this kind of a system for AI-assisted adjudication, both in terms of the due process values and the decisional authority. That is, do you start to, for instance, reallocate decisional authority for locating relevant precedent away from the staff attorneys or veterans law judges toward the engineers who are building out a system like this, which of course relates to the much broader conversation that many of us are engaged in terms of algorithmic governance. If you go to the next slide, Matthias, I think the kind of concrete use case here really does come from the Social Security Administration, where Gerald Ray, who was head of the Appeals Council, had started to hire attorneys who also happened to have data science and software engineering backgrounds, had them learn the adjudication process, and then had them start to build out simple prototypes that led to sort of the first NLP-based error detection system, where staff attorneys and judges can input a draft decision and get around 30 quality flags, such as the one depicted here, that starts to use both heuristic and machine learning ways of spotting internal inconsistencies within the decision, like the one here. If you could go ahead and advance to the next slide, that, of course, then is what is one of the biggest kind of potential upsides to this kind of a system, is that one could go back to the original diagnosis provided by Jerry Mashaw of these kinds of NLP-based systems as really fostering better forms of bureaucratic justice in the kind of internal management system that Professor Mashaw had talked about, which connects to some of the broader work about the ways in which government agencies are starting to rely on forms of artificial intelligence to improve governance functions within the public sector. With that, we'll leave it open for questions. I think we can probably unshare the screen. And Lara, I don't know if you want to take over.
Hi, Professor Denhu, and hi, Professor Matthias Grabmeier. Thank you so much for your presentation. It's a really interesting paper. Now we are officially open for questions. Until now, we don't have one, but I think I think our audience is just writing one. Just a second, please.
While that's happening, and maybe to give people a little bit of time to kind of get their questions together, Matthias, I think this has been just a really wonderful collaboration, because it's got kind of the direct collaboration both on the technical side and on the domain side. But maybe, Matthias, do you want to? One of the things we didn't present was sort of some of our thoughts on like next steps of where to kind of take a system like this. So I don't know, I'll throw a question over to you, Matthias, until we get a question from the audience. What do you think? What are you most excited about in terms of next steps?
Thank you. I also I'm very grateful for this great opportunity of collaboration, and everybody learned a lot over the course of this project. Technique-wise, there's of course a lot of things to be interested in here. Immediate next steps would be similar, Dan, to your group's other paper, would be to evaluate how much domain-specific pre-training would, for example, help models like this. The other thing we have been looking into is generalizing to the problem, again, now that we've established with some success that next citation prediction can be treated as a classification problem, can we make the task harder and move one step towards text generation in a way that does not suffer from the susceptibility to generate, say, implausible citations or other distractors that are not perceived as useful by the user.
Yeah, I would add one thing to that as well, which is concept drift, which is if there's a change in precedent by the Court of Appeals we have not yet focused on a system that really is able to detect that and to recommend substitution from historical precedent that, for instance, might have been overruled into new precedent. I think that's going to be a very important one to actually have a system like this operate in practice.
Okay, thank you so much. We now have one question from our audience, and they ask, Mr. Hu, could you please elaborate for us on how accessible this kind of technology would be for the use in countries that don't adhere to the common law? I think the audience is asking about the civil law.
Yeah, it's a great question, and I think probably Matthias may actually be better situated to answer that, since he does have familiarity with the German system. But maybe one thing I'll just start off in terms of an answer is that we may have glossed over this a little bit too quickly, but this is actually an interesting adjudicative scheme because it's sort of has elements of the common law, but a lot of this is regulatory law. And so we had three different classes of citations: statutes, codified regulations, and case law. And so, you can kind of think of the task in a more civil law system as being one to kind of help adjudicators identify the right code provisions. And I think that's where a lot of the kind of pre-processing that Matthias described becomes really important. But Matthias, you have more familiarity with a different, a non-common law system. So I'd be curious to hear your thoughts on that.
Thank you. I agree with your first answer, and would like to emphasize this just a tad more, in the sense that our system is in a sense source agnostic by predicting solely based on use patterns. So we're not restricting it to cases, or it's not restricted in its current form to just cases or statutes or regulations. And in a civil law context, one could think about the fact that the system would pick up on common commentaries, for example, or other kinds of regulatory support documents, preparatory works, and so on and so forth, that would be cited in civil law context than you would cite precedents. So I think the basic architecture applies. However, I think it remains an open research question, or a sort of proof of concept question, whether legal reasoning that contrary in civil law countries, that contrary to common law, doesn't take as much recourse to specific facts of prior cases. So generally it will be more terse. There will be sort of less borrowed language and things like this, and less verbatim quotations. So the data distribution will change, but the basic task of predicting a source in a textual context will be the same, even if what's in the context will be a different kind of discourse.
Okay, great. We also have another question from Mr. Hannes Westerman. The question is, how the mentioned changing of precedents and maybe the discovery of new general principles of law may affect the processing of the tech? How the mentioned change of precedents and maybe the discovery of the new generation principles of law may affect the processing of the tech?
I think the way, at least I'm interpreting that question, is as related to what I had mentioned earlier to concept drift. That is, suppose there's a change in precedent by an appeals court. How does one build out a system and build out the architecture to ensure that it doesn't, for instance, keep recommending a case that has been overruled? And I think what would, of course, be very, I guess I have a couple of thoughts on this. One is that it would be very valuable to start to build in the kinds of citation signals that we see in, commonly used research tools for lawyers. But another really interesting source of information to exploit when those tags may not necessarily exist for a body of veterans law, for instance, would be to actually leverage the fact that there are real quality differences in adjudicators. There are some adjudicators who pay a lot of attention to immediate changes in the law and are much more rapid in their adoption of new precedent. And that would be a very interesting thing to kind of explore, given that we see the identifiers of the different adjudicators, and could potentially start to understand which adjudicators are the ones that are signaling to you that the historical recommendations may no longer be accurate. Matthias, I don't know if you have other thoughts on that front.
I agree. So if you in the paper, there's a graphic which I'm not showing you showing off in the interest of time, where we observe that it does not for many instances in the data, the system doesn't need a lot of training examples in order to predict the use with the citation with high accuracy, with high recall. So I do think that the data threshold of how much does something need to be there in order for the system to pick up on its use can be, depending on how varied the language is, relatively low. So I think we end up with this sort of cold start. So Dan calls it concept drift. From a machine learning standpoint, I sort of call it the cold start or sort of sudden stop problem, where something used to be, we should predict something up to now, and now we need to stop doing it. And we didn't see this before, but all of a sudden we now need to start predicting it. And I think this is in part where, and I agree with Dan entirely, where I think a merge of language-based pattern recognition, a hybrid approach of language-based pattern recognition with some intelligently curated metadata, structured metadata that is simple enough to be maintainable, but expressive enough to be useful for a model. I think that's where we want to go in the future.
Okay, great. We have more questions, but unfortunately we don't have more time. So your presentation is going to be streamed tomorrow, and then we are going to request or take all the questions that they made today and ask you tomorrow, and also the questions that they can make tomorrow as well. Thank you so much for your presentations. And now I would like to introduce Mr. Andrew Paley, who is PhD candidate at Northwestern University, and will present the full paper From Data to Information, Automating Data Science to Explore the US Court System. Mr. Andrew Paley, you have 20 minutes of speech. Afterwards, we are going to move to questions. The stage is yours.
All right, thank you very much. Thanks a lot for having me. Just getting set up here. And I hope that you are seeing my full slide deck. Is that true, Laura? Can you confirm? All right, well, yes, we're gonna go with it.
Yes, I can confirm.
Okay, great.
Yes, sorry.
Full screen, great. Great, so my name's Andrew Paley. Like she just said, I am a PhD candidate at Northwestern University. I work in the C3 lab, and I'm here today to talk to you about our paper, From Data to Information, Automating Data Science to Explore the US Court System. So the important thing here is, sorry, I'm having a bit of a technical thing, one moment. So to frame this, to step back and put a frame on this whole thing, the US federal court system might feel like a monolith, and it might seem like one massive unit, but in fact it's a tapestry of countless unique decisions made by individuals across hundreds of thousands of cases filed annually, as those cases work their way through 94 district courts, 13 circuit courts, and on up to the Supreme Court. Now, to get an understanding of what's actually happening in this court system, we have to actually be able to answer a series of questions. And those questions, and there are a lot of those questions, they include how often are fee waivers granted? Does it differ by district or case type? Do judges treat parties differently if they're self-represented, if they don't have legal representation? Do cases take longer in some districts versus others? Does that change by case type? Do judges nominated by different parties behave differently? And has any of this changed over time? And getting to the answers to these types of questions from the raw data produced by that massive system is in some part a technology problem, but it's also a problem of understanding domain. It's a problem of understanding the questions to ask. So the work we're doing and the work that you present in this paper is actually part of a broader initiative called SCALES. And SCALES is composed of about 24 individuals working across law, computer science, journalism, and social science at a host of different US institutions. And they're all working towards, we're all working collectively towards this one goal, which is to bring transparency to the systems and processes of the US courts, ensuring that they are fair, efficient, and accurate. Now, there are different parts of this problem, and different groups within SCALES are working on different pieces of it. But the one we care about and what's covered in our paper is how we go from the data, the information created by that system to the answers to those questions I presented a moment ago. Now, when we talk about data from the US court system, we have to at least note PACER. So the PACER system, the public access to court electronic record system, is paywalled. So this is how we get access to public records, the court records, but they cost money. It's 10 cents per page, maxed out at $3 per document. The result, in effect, is that analysis at a system level is prohibitively expensive. If you care about one case or 10 cases, getting the documents associated with that is not a big deal. You start to do system level analysis across tens of thousands, hundreds of thousands of cases, and it becomes too expensive to bear in most cases. That is not the focus of the work we do in this paper, but it is something that the broader SCALES initiative is focused on. How are we getting access to the data from all the different districts, and also tracking pending legislation that's working through Congress to address this problem. Now, but let's say we had the data. So let's imagine a world where all that data was actually available. You know, there's a version where we can sort of high five and we go home and we're happy with the fact that we made the documents free and we put them online. And that is a reasonable end state for a lot of open data initiatives. But you know, this is sort of the put it all online, let someone else sort it out approach to information access. And I don't think it's hard to imagine that if you went to someone who cared deeply about the court system, about justice in the United States, say a legal scholar, a lawyer, a journalist, and you handed them millions of documents and they wanted to understand something about the system broadly, they might feel like that's a relatively opaque form of transparency. So this is where the work that we cover in our paper actually starts. And so the big idea here is there's two hops in our paper. There's two tracks. One hop is from documents to structured data. And that is, that's what we cover here. And the other hop is how we get from data to the answers to those questions. But documents to structured data, what are we starting from? We're starting from 270,000 case documents, case dockets, excuse me. If you're not familiar with what those look like in the US, that's really just the overview of a case. So that's the district, the name of the case, the judge or judges, the parties, the type of suit, criminal or civil, the nature of suit, if it's civil, who are the lawyers involved, if the case is finished, what was the date terminated, and what was the outcome. And in between, the docket entries trace all of the events within a case. And those are unstructured text. Those are hand entered by people. They're different across districts. They can be different based on just the clerk entering them. So how do we go from that to structured data? A database of 25 to 30 tables. Takes extraction. We have to pull those HTML documents apart. It takes enrichment. So we're deriving a bunch of additional data points. The simplest example of that is case duration, where if the case has finished, We have a date filed, we have a date terminated, and on the way in, we're deriving, the length of the case in days and storing that. There's a host of other features we're deriving like that. It includes language modeling. By the way, all of this is covered in more depth in the paper, so there's plenty of details to dig into there if you're interested. The language modeling component, as we talk about in the paper, we're using to classify docket entries. So the early experiments are related to motions. We want to be able to track, if a docket entry is a motion, and then it's a motion of what type. From here, the ongoing work is classifying other types of docket entries. So orders, one example, responses to motions, case outcomes. And so that work rolls forward. Sort of implied by that is the notion that we are ontologizing cases, right? We're trying to get to the right layer of abstraction such that we know what tags to generate, what types of features to look for, so that we can create sort of the overall map, the contour of a case for the sake of case comparison. So this work is one thread under the scales banner. Like I said, the details are included in more depth in the paper. And it's the hop from documents to structured data. Now, there's a version of the world where we say, great, now we're done, right? We've done the work up front to go from these unstructured or semi-structured, this raw data, and brought it into structure. We've done the world a service, and we put that online, and people can now come and get the information out as they see fit. That step of getting the information out as they see fit, of course, takes one of two things. It takes skills or it takes resources. So skills, you want to make use of 25 to 30 tables with millions of entries. You need to know how to write code, create SQL queries, generate visualizations, possibly work with language models, etc. Or you need resources. You need to be able to hire someone that has those skills. This is like, data scientists as the human interface, or graduate students in some cases. So if you don't have skills or resources, then if you're a journalist or a legal scholar who actually wants to understand that data, to ask questions, to get the answers to the questions we looked at up top, then we get to a place where open data is actually necessary but insufficient. And this is true broadly. So we're talking about US federal court data right now, but any open data, open government initiative that stops at we've put the data online somewhere, now you go figure it out, is sort of half the battle. And what we really want is open information. And this is really what we mean when we say open data. It's sort of a proxy, but it's a halfway. So how do we bridge this gap then? How do we go from structured data to information? Well, what we're getting into then, just like the title of the paper suggests, is automating data science. And the goal for this second track of work we cover in the paper is that we want to empower non-technical users with the tool set necessary to drive data search and analysis without a data scientist in the loop. How do we do that, right? And that's what we'll be talking about through the rest of this paper now, for this presentation. Well, if we want to automate data science, we have to understand what data scientists do. And we're sort of rolling it up to 3 high-level buckets. No offense to any data scientists in the audience. Of course, there's a lot more to it than this. But the sort of interaction pattern starts from when a domain expert enlists a data scientist to dig into data. The data scientist needs to take stock of what's available and surface the space of the possible back to that domain expert. This is the data we have on hand. This is what we can do with it. They then can listen, have conversations with the domain expert, and translate the information needs, the questions, back to queries and analytics. And then when an answer is arrived at, bring that answer back and communicate it in a way that's clear to the domain expert. So if we want to automate that, if we're trying to build a platform that fills that role, we need a system that doesn't remove the complexity of data science or data analysis. It instead puts as much of the burden as possible on the machine. That is the Saturn platform. That's what we're building in the C3 lab. We don't name it in the paper. We discuss it in detail, the version 1 of it. But the name, we've given it now Saturn. So the scales application, the demo I'm about to show you in a moment, is an instance of Saturn. And we'll dig into the particulars during the demo, but the things to take away at this level, looking at this bird's eye view, is that the user experience is what we call a natural language notebook. You might get the riff from Jupyter Notebooks if you're familiar with them. We're borrowing from the paradigms of data science tools, but instead of saying the inputs are code, we're saying those modular steps, that sequential data exploration, is now supported by simplified filters and plain natural language statements. The other thing to note as we go into this is that the system itself has nothing about any domain or data set hard-coded in it. The query generation, the analysis engine, the search components, the API, and the front end, nothing about a particular data set. That's brought to the system through an ORM layer and an ontology configuration. I don't have time in the presentation to go deep on this. We cover the V1 in the paper, but the long and short of it is we need that specification of the database, the ORM, the list of tables and fields, and we need a little bit of metadata on top in V1. And this is stuff that abstracts away the schema and brings it closer to the mental model of a domain expert, someone who's asking questions, right? So this is stuff as simple as, it's not 3 or 4 fields that are strings in a particular table, it's a judge's name and they have a relationship to a case. So when a user says, I want to search by judge's name, they're not thinking about the particulars of the joins and the underlying fields, they're just entering some text and the system takes care of it. This also includes stuff like, it's not just a float, it's a case duration and it's measured in days. So where we're headed in V2 is collapsing this all down into a much simpler representation that looks a lot more like a standardized ontology with entities and attributes and relationships and a hierarchy. And that part is not in the paper. That's a matter of future work, but we're really excited about where we're headed with it. So demo, I'm gonna jump out of this and move my share over. Okay. So I trust at this point you are seeing a web browser and someone shout if not. So what we're looking at now is a Saturn notebook. It's an instance though of the Scales platform. So the data that's loaded in is the data we've been talking about, right? This is case, these are case dockets. So if I open any of these up, I can dig around in the actual data of an individual case. But we want to support that, but what we care about most is asking questions across the whole data set. So let's collapse that data view. There are 267,000 dockets loaded in there, and I'm going to add a filter. The filters are, again, derived up from that layer of data semantics on top of the database. I'm going to say district. I want to look at the Northern District of Illinois. It's where I'm from, but also it's where we have the most data currently. So I make a selection and the filter updates. So now I'm looking at, now my data context has 104,000 case dockets in it. Let's ask some questions. So I'm gonna add some analysis. The system asks, what do I wanna know about? In the current iteration of the platform, we're presenting this as a sort of search or select dropdown, but it's, as you can see, it's not a great browsing experience. These statements are all the permutations of analysis that the system knows it can do, that it has inferred from states in the data, as well as what it knows its core analytics engine is capable of. So it's better to search than to browse. So I'll search for duration, and let's find out how long cases take in the Northern District of Illinois. So on average, they take 348 days. That's a really quick response to, search across or analysis across 104,000 cases. I can find out a little bit more if I want, a description of that metric, how it was derived, which again is pulled up from the underlying representation, and the data validation details. So the system will tell me, hey, you wanted to run analysis across 104,000 cases, but 6,000 of them actually didn't have a value that I could run an aggregation on, so I omitted them. We're still looking at an average across 95% of the data. And by the way, in terms of average case duration, that's just because the case hasn't ended yet. So we don't have a duration calculated. So now I might want to say, I want to know about that over time. How has duration changed year over year? Oh, gotta spell year right. I'll make a selection And this time, the system will respond with a line chart. And this is because it understands when I'm talking about something over time, a good way to present it is line chart. If I'm talking about a distribution, a good way to present it is bar chart, and so on. So now I've answered a couple questions. I get a sense of how case duration has changed year over year, and a little interactive chart. And now I decide I want to drill in more. So I can add a second filter. This time I want to look at cases with a nature of suit related to intellectual property. So I'll select that.
Really just 3 minutes last.
Yeah, I got 2 or 3 minutes and I'll be done. Oop. So property rights, that's what I wanted to search. So nature of suit, property rights, which I know is tied to intellectual property. And note that from that data context updating at the top, the questions below now update. So now with that additional filter, we see that cases go much faster when they're related to property rights. And interestingly, we see they sped up, right? And so from here, I might want to ask a whole bunch of follow-on questions. For the sake of time, I'm only going to ask one more. I might want to know about caseload per judge, right? And I could ask that question directly, but I could also break that caseload picture down by different dimensions. And so I will do cases per judge year over year, broken down by judge tenure. Let's see where that is. Cases per judge, group per judge tenure. Here we go. And so now I get a much sort of deeper portrait of the analysis. And I see that actually right about when those cases were speeding up, as I can see from this particular chart, that's when a whole bunch of brand new judges who had been on the bench less than 5 years, started to actually get those cases. So I can't go much further, but what I hope this is giving you is a sense that I'm able to explore the data very flexibly, apply filters, and ask a whole bunch of different questions in this notebook format without knowing code, without knowing SQL. And so just to wrap up, early results are looking promising. I trust you can see the slides again. Early results are looking promising.
Slides. Yes, we can see the slides.
Cool. Preliminary user testing across 15 subjects. We're actually in a second round of user testing now, but the first round, we had people complete tasks within the system. They came back, they filled out a survey. We got high ratings on usability. We got a 73 sus score, which is considered good usability. We detail these results more in the paper, and 87% responded that they would use the system frequently. Future work, there's a track of work on the data that involves more language modeling, more data enrichment, and blending of additional sources for court records, including state courts, Supreme Court data, and then other sources like census data. And then future work on the platform involves expanding the analytics, refining the user experience, multi-data set exploration in one view, bringing new data sets through the UI, and a whole bunch of interesting things that flow out of that. In-platform language modeling, language model training, which we'll get into in future publications, as well as expanding the purview. So we're bringing this to political data right now. We're looking at bringing it to education-related data and alternative user experiences. And so on behalf of the team on the paper, I want to say thanks, and I want to acknowledge the National Science Foundation for supporting some of this work.
Okay, great. Thank you, Professor Andrew Paley, for your great presentation. The first question that we have is that this system is available for testing.
We're actually working towards an open
for
beta.
a researcher from another country.
Yeah, so we're working towards an open beta, and I would encourage you. I flashed my email address right there at the end briefly. Oh, can you hear me? So we're working towards an open beta. I had my email address on the screen briefly at the end there, and I invite anyone to reach out to me. We hope by later this year to invite more users to take advantage of the platform in an open beta.
Okay, great. I think they will be anxious to use it. And the other question that we have is, in the paper, specifically in the future work section, what is the author opinion in the cited transparency in the US court system as a database of the proposed model? And what would be a rebound if the US courts decides in the short future to enter into an opacity instead of the stated transparency? Did you understand?
I heard most of that. I think so. Is the question related to whether if the courts were uncomfortable with this level of transparency? Oh, I see you added in the chat. Great, thank you.
Yeah.
Okay. So if the truth of the matter is that because of the way the data is, the way that the system is set up, court records are deemed public records. So the friction associated with the paywall is friction, but legally speaking, the court generates, as a part of our government, generates public records. So they can't prevent us entirely from having access. They can add friction to it. So that being said, there is an open question as we bring more transparency to the court system of how that will be perceived, and that is a conversation happening with the broader scales team. But we hope that is a positive thing across the board, that people realize that more engagement, more civic understanding is actually a net positive, regardless where you are in the system. I think we're having some technical difficulties, but I hope you all heard that answer.
Yeah, I have some technologies, so sorry, I couldn't hear. If you could repeat the last part of your answer, if you don't mind.
I was just, oh, sure. I was just saying that they are in fact public records, and we hope that what the work we're doing is recognized as a net positive across the board by all members of the system. That transparency is a good thing, civic engagement is a good thing, that this is, after all, a democratic country, and we hope that the transparency is not seen as a threat, that we hope it's seen as a net positive.
Okay. Do you have any action plan to continue to be transparent and to avoid the opacity? Or do you believe that your model is already transparent?
So to avoid opacity, sorry. So do you mean like in our platform, once we have the data?
Yes.
Do you mean, okay. So providing the data very well could be part of the broader scales initiative. What I'm talking about is the platform that helps people take advantage of it, but absolutely, downloading the data directly, if people want to get their hands on it, that is part of the broader roadmap, getting access to just the raw data, if that's the nature of the question. I'm sorry, I misunderstood.
Okay, no, it's okay. Thank you so much. Okay, I think we don't have no more questions for this panel, so I would like to thank you, Professor Entropelli, once again to give your presentation. And your paper is very, very interesting. Thanks so much.
Thank you very much for having me. I appreciate it.
Now I would like to introduce Mr. Devil McConnell, who will present the full paper, Case Level Prediction of Motion Outcomes in Civil Litigation. Devil McConnell is a second-year PhD student in the Department of Computer Science and Engineering at the University of Connecticut. Prior to my PhD, he received his Bachelor's of Science in Computer Science and Applied Mathematics at the University of Rhode Island. Mr. Devil McConnell, you have 20 minutes of speech. Afterwards, we are going to move to questions. The stage is yours.
Great, thank you so much. Alrighty, let's start slideshow. Okay. And sharing the screen. Share. Alrighty. So as we mentioned, my name is Devin McConnell, and this is the case level prediction of motion outcomes in civil litigation. So some background information. Lawyers regularly predict what courts will do and what to argue, when to settle, when to sue or prosecute, and when to reduce client liability risk. However, these predictions tend to be overconfident, not well calibrated, vulnerable to some bias, and advocating for a particular view. Therefore, recently, machine learning has been on the rise to aid in these predictions. In some scenarios, machine learning methods have been predicting judicial decisions with an accuracy that exceeds legal scholars. So using machine learning also has the potential for reducing litigation disadvantages faced by the poor, racial minorities, and other vulnerable groups due to court outcomes varying with the attorney quality and client resources. So one example of machine learning being used in legal predictions is the development of a random forest classifier on US Supreme Court data depicted here on 240,000 justice votes and 28,000 case outcomes. In 2004, machine learning was actually able to predict justice votes with a greater accuracy than legal experts, which is seen on the left of this slide. And then on the right, we're seeing machine learning being able to predict individual court outcomes with a greater accuracy than legal experts, split up by the category of that outcome. So the previously discussed methods focused on court opinions, which ignored many important formal procedures that lead to a final judgment and use features that are not available during litigation. In this work, we present machine learning methods that predict court outcomes at the level of individual motions. The goal of these methods is to provide client and lawyer support tools. We hope to reduce litigation disadvantages faced by vulnerable groups due to variability in the attorney quality and client resources. So here we are focusing on predicting whether a motion to strike is going to be granted or denied. And here I'm going to be showing the complaint document of a motion to strike in New Haven, Connecticut. And a motion to strike has a significant influence on a case's outcome and therefore is an important factor in legal decision making. In Connecticut, a motion to strike is a written petition for a defendant to a judge to remove part or all of a plaintiff's complaint allegation based on a legal insufficiency. So here we are providing an overview of the pipeline that we used for our work. And we computed two sets of features from the state of Connecticut's judicial branch court administrative database, which we're going to refer to as the minimal and subset features throughout the rest of this presentation. So this database contains administrative and procedural data for all civil court cases in Connecticut. These features were also combined with natural language features from complaint documents, and we then used a grid search to fine-tune the hyperparameters of the 6 machine learning models that we used. So starting off with the data collection of our pipeline, we used information from the court database that we had from Connecticut and the complaint documents we gathered as well. So starting off with the documents, many court documents are filed over the course of legal proceedings that are relevant to motion outcomes. We focused on complaint documents because they contain the facts alleged and legal claims that are asserted. They are available to all parties when a lawsuit begins and can therefore be used to support any decision making. For these complaint documents, we needed to convert them to text-based files so that we can use them during neural embedding feature extractions. So in the PDFs, if they contained images, we had to use Tesseract, which is an optical character recognition software maintained by Google. And we use this to convert images to text with higher accuracy. And when it only contained text, we used PDF to text, which could convert the text in the PDF to just a text file for us. And then we had the input from the court administrative database itself from the state of Connecticut judicial branch. These features are useful for the prediction of motion outcomes. And here I'm showing just a handful of the ones that we found useful. So case reference number and motion ID on this slide are ones that helped us map the cases to complaint documents, while case location is a one-hot encoded feature. Case major code, here we only use vehicular cases and tort cases. Motion result codes, we only used ones that were granted or denied, so GR or DN. And then motion filing party, we only use D for denied. And then motion juris number is just the attorney juris number for a given attorney. This feature also helped us create the attorney specialization feature, which will be described shortly. We ended up extracting 7,904 motion to strikes from the database. So all in all, we defined two feature sets from the database. So the first we defined as minimal, which contained the motion juris number and the attorney specialization. And then we also defined the subset feature, which contained case location, case major code, motion juris number, and the attorney specialization. It's also important to note that this data was pretty well balanced, with 54% of the motions being granted, 46 being denied, 47 being vehicular, and 53% of those cases being torts as well. And then moving on to the feature engineering, and we'll start off by talking about the attorney specialization. Attorney specialization is derived from the case distribution of major codes for each individual attorney juris number. Again, we are only looking at the torts and vehicular cases from the database. So here we use Shannon's entropy, whose probability vector is the relative frequency of major case codes. In this figure, we sorted the juris number on the x-axis by the entropy, and we see many lawyers have a high specialization, which means they have a lower entropy. But many of these cases are because we don't have much data for some of those attorneys. But to combat this problem, we worked on something to smooth the entropy with the Dirichlet multinomial, which is depicted on the right, which means we noticed that actually we don't have as many attorneys that are specialized as we originally thought. So the difference between using regular entropy and the smooth entropy can be viewed here on the left. So in this image, it shows many people being specialized, but it's because we don't have that much data to make a formal decision on whether they are specialized or not. So this could be because they only tried one or two cases in a specific area. But on the right, there's a Dirichlet multinomial smoothing out the entropy, which is controlling the variance of the entropy for the attorneys with small caseloads. We also built features based on the complaint documents. So rule-based features will map a condition to a class, where a condition is a group of Booleans for words in documents, and the class is a motion granted or denied. An example of this is if we have a complaint document, we can call it 1109, that contains car accident and negligence. And all of these words are also considered to be in the class denied. It would map to a label true, which means that this document is going to be a denied document. So we then took these rules that are learned by this classification during the rule learners to aid in our classification tasks later. So in this work, we also developed two versions of the rule-based learner algorithms, one of which is called the simple rule learner, and the other is called the first order inductive learner. So the simple rule learner algorithm is a greedy algorithm that adds a rule with it when it increases the accuracy of the model. So it counts up the frequency of the words in a granted document, which is going to be denoted here as a green box, and counts the number of the times that word appears in all the documents. And it also, we use a grid search to determine the threshold of when to pick a word to be either granted or denied. So in this example, as mentioned, we use green squares to denote a granted document, red squares to denote a denied document, and green highlighted words to denote whether the search term was a granted word. This means the word is a rule that maps documents to a granted motion outcome. So here, the simple equation is going to be the number of granted words plus 1 over the number of words appeared in all the documents for that term, plus k, where k is the number of classes you have. So here, our k value is actually 2, so our result for this is 4/6. So the other model is the first order inductive learner, which tries to balance information gain with the documents covered. Here we're keeping track of the number of complaint documents that are granted and the ones that are denied for a given rule. But we also need to keep track of the ones that are turned denied when they are originally granted and the ones that are turned granted when they are originally denied. So here we're denoting the granted documents as green documents, so green squares that only contain the green words, and red squares that only contain the red words for denied. And we can denote the documents that become denied documents as green squares with only red words, and the same goes for the denied documents becoming approved documents. So this means a green highlighted word is a rule that maps documents to a granted motion outcome. And in contrast to rule-based features, neural embeddings attempt corpus in as input and outputs vector representations of the words while trying to maximize the log probability of some word for some input word. While doc2vec is very similar to word2vec, instead of using just the one input word, you're taking a vector representation of that document to condition on. We also investigated a model called law2vec, which is a corpus-specific model of word2vec, and it used 123,066 documents that were on the United Kingdom legislative documents, European legislative documents, and several thousand English legislative documents. And to continue to make richer representation of the legal documents that we worked on, we investigated term frequency inverse document frequency, also known as TF-IDF. So you would do the term frequency multiplied by the inverse document frequency, where term frequency is the number of times the term you are looking for appears in a document over the number of words in the document. So here, the number of times the term appears in a document is going to be highlighted as pink, so 27 over the total number of words in that document is going to be 400. And you're multiplying it by that inverse document frequency, which is going to be the log of the number of documents in your corpus, which is 5 over the number of times that the word is contained in a document in your corpus, which is 2. So it's important to note that TF-IDF has shown success in natural language processing and aiding in increasing the accuracy of classifiers. And in recent years, TF-IDF has shown usefulness in corpus-specific weighting. And specifically with this, we'd see a weight of 0.027, which this weight would actually be useful to increase the accuracy score of our classifier, especially when we use it as a weight on a word2vec model. And it's important to note that a higher TF-IDF weight would represent a term that is in smaller amounts of documents, but more times, and a TF-IDF weight that is smaller is in more documents, less times. And then all three of these methods that extract information from Word documents are useful as standalone ways to improve your classifiers, but we can do better. So we can combine all three of these methods to make one method to increase the classifier accuracy. And we can do this by taking the TF-IDF weight and multiplying it onto our Word2vec model embeddings that we extracted, and only using the rules that we extracted from the rule learner algorithm. So first we would do identifying the important rules from a rule learner, which for us, we identified that the FOIL algorithm was better off than the simple. And then we would only extract the word-to-vec embeddings from the FOIL list that was generated, and also only the TF-IDF weights from that FOIL list as well. We would multiply the TF-IDF weight that corresponds to negligence onto the negligence vector from word-to-vec, and then average out that vector for all of those word-to-vec so that we would have one averaged out vector to create a document representation of our complaint documents. So now we'll talk about the parameter optimization and machine learning models that we worked with.
Devin McConnell, just 5 more minutes, please.
Okay. So we trained 6 models: AdaBoost, gradient boosting, extra gradient boosting, support vector machines, decision trees, and random forest. So a tree classifier aims to construct a hierarchy of decision rules that recursively splits the data until a leaf is reached that denotes the inferred class label, which is seen on the left. And then boosting is a general ML technique based on building an accurate learner from an ensemble of weak learners. This is similar to using an ensemble of tree classifiers with low depth. And then we also use support vectors seen on the right that tries to classify the data through solving a convex optimization problem, yielding a hyperplane that optimally separates 2 classes. We then optimize the parameters through a grid search using a 70-30 testing and training and testing split with a 10 cross-fold validation. And then to quantify variability in these fine-tuned models, we did 100 bootstraps. So to then figure out what version of the features we wanted to use versus minimal and subset, we wanted to quantify their difference. So here, just a refresher of minimal and subset. Minimal only had the attorney specialization and motion juris number, and subset contained motion juris number, attorney specialization, case location, and the major case code. And on the y-axis here, it's the motion classification accuracy, which is going to be the proportion of correct predictions to all predictions. And on the x-axis, it's our models, which again are the AdaBoost, decision tree, gradient boosting, random forest, support vector, and extra gradient boosting. So here we did notice that adding and using the subset features with case location major code increased our accuracy overall. And we had the best performing with decision trees. So the median and mean accuracy on this model was 0.583. So we ended up only using the subset features for the rest of our results. And then we also investigated our 3 models across all different methods and compared it to a baseline classifier, which the baseline classifier had an accuracy score of 0.501. And just looking at the database features, we've noticed that the database features did score better than this baseline, but less than 0.6. And every time we added doc-to-vec and word-to-vec onto these database features, we did see an increase in accuracy score, but our best performing model was the one that had the FOIL, word-to-vec, and TF-IDF added onto the database features. And just so you know, as I mentioned before, the FOIL, word-to-vec, TF-IDF is the model that we averaged the word-to-vec weighted by TF-IDF from only the words that were learned by the rule algorithm. So this model gave us a 0.644 accuracy from our grid search and a mean of 0.605 from the AdaBoost model. And our decision tree had the best mean of 0.606. And we also tested the difference between predicting torts and vehicular cases for the database combined with FOIL, word-to-vec, TF-IDF. and noticed that SVMs were an outlier in being able to successfully predict the vehicular cases with considerable accuracy. Last piece of results here, we also calculated the feature importance from the decision trees, which feature importance is useful to let us know how the model's features contribute to predicting what we're trying to guess here. And here we're showing on the vertical axes the grouping of features from the TF-IDF, whether it be TF-IDF simple or the subsets. And then on the x-axis, it's the non-zero for at least one of those configurations. The last column is the sum of the word-to-vec features. And then we did note that major case code, attorney specialization, and word-to-vec have the highest average importances across the board. So then quickly to conclude, we did develop a pipeline that includes feature engineering rooted in legal domain. We also developed and benchmarked the first machine learning method to predict motion outcomes, also demonstrated that motion to strike outcomes are predictable with high accuracy when you use features for attorney specialization and with natural language processing. We believe that this can be useful to predict the survival rate of motion to strike with a complaint document, and believe that it can help parties to make more informed settlement decisions, as well as help rewrite complaint documents for better outcomes. And then our future work, we think better investigation in corpus-specific neural embeddings like transformer models such as BioBERT, LawBERT have seen great success, so that could be helpful. We also aim to expand this work to other motions like motions to summary judgment. Also hope to create a web interface for easier access and interaction to our models and for attorneys and clients. And then we hope to collect more data from surrounding jurisdictions and states. And we also aim to compare the results to a legal expert panel for our future work. And then just a quick thank you to the state of Connecticut Judicial Branch for providing us with our data, and my lab for the great support they've had over this past few weeks preparing, and my co-authors for the legal knowledge they provided and help with all the code. And if anybody is interested in this work, all the code is available at my lab's GitHub at Aguiar Lab Motion Predict. It has all of our rule learner, TF-IDF, word embeddings code to extract and combine the work, along with our grid searches, bootstrapping methods, and parameters for the models, as well as the models.
Hi, Devin. Thank you so much for your presentation. It's really interesting, and it is really useful to share your GitHub address. I think it would be nice to visit and to understand more about the model. So we have one question already. I'm gonna read for you. Just a question. Great work. I understand that relating the motion outcome to certain words. Could you elaborate more on how to select those words? I could imagine that some words would appear in both granted and denied cases. How would you resolve that?
Yeah, so the way we were doing it, we worked on developing oh, you sent it in the chat.
I just copy pasted the question, maybe it's easier. So, and it's a compliment about the work, and how do you elaborate, and how do you not appear when the granted and denied cases, when you resolve, how do you resolve that?
Yeah, of course. So what we did, we worked on looking at the two rule-based learning algorithms. So one of them, like I was saying, was the simple algorithm, and the other one was the FOIL-based learning algorithm. And of course, that does happen. Some of them do show up in the granted and denied cases. They're going to potentially show up more in one over the other. So we did perform a grid search to solve this problem to figure out what the best scenario is to determine if one is going to figure out the cut off of where this might be. So that's pretty much how we handle this, and using a testing and train split with a cross validation as well. So that was a 70-30 split with the cross validation of 10 as well for these.
Okay, great. If the author of the question have more questions, if not clarify, please, you can send us more questions. Until there, we have one more question that I'm going to copy paste here and read the question for you. How accurate can this kind of technology be in countries and legal orders or legal themes where jurisprudence is in constant change due to the new legal thesis?
That's a good question. I would imagine, I'm not particularly sure, I would imagine it should still hold up, considering there is work with United Kingdom legislative work as well as European legislative work. So I believe it should still hold up as long as people have similar court work, such as motions to strike and complaint documents. So as long as there is work along that lines, we are working to expand this to other types of courts as well. But I believe it should.
Yeah,
I'm not too sure.
I think, yeah, it's a difficult question. And I was wondering that when you said that the next phase of your project about your paper is to work with a legal panel, maybe it can be some hypothesis that you can work together, like trying to understand the different changes in the different legal themes.
Yeah, definitely. I'll have to keep that one in mind. So great question.
Great. I'm not sure if we do have any more questions. I don't think so. I'm just checking out. Okay, I think we don't have more questions, but you will still remain 3 minutes, 2 minutes now, if you want to do a closing with the final words. The floor is yours.
I think, yeah, so if anybody is interested, I can flash my last slide again for the GitHub, but we are definitely interested in people taking a look at our work and giving feedback if people are interested. So there's this, and yeah. So.
Oh, great. It's really nice. I think it's good to share this. So thank you very much for your presentation and for your participation in our Congress. And now I will just finish this panel with the 3 great presentations. Thank you so much for all the professors, Professor Dan Hu, Professor Matthias Greb-Mahir, Professor Andrew Paley, and Professor Devon McConnell. Thank you so much, and we are going to a short break. See you in a few minutes. Bye-bye.
Hello, everyone. My name is Gabriel Borner. I'm here presenting ICAO 2021. We thank everyone for the present attention on this panel. We would like to thank Jaromir, to thank Hannes, to thank Nicholas, and to thank Adriana for their presentations at this moment. We will begin with Jaromir and Hans. I will let them present themselves.
Thank you very much, Gabriel. I'll ask Hannes to share his screen.
Yep. Can you see it?
All right. Welcome, everyone.
Jaromir, sorry. I just like to first you could maybe present yourselves, and then you could begin your presentation. I just need to thank our sponsors. Just a moment.
Okay, I see.
Sorry.
All right. So the first presentation will be delivered by Hannes Westerman from the Cyber Justice Laboratory at the University of Montreal, and myself. My name is Jaromir Savelka, and I'm from the Carnegie Mellon.
Okay. Well, in name of the ICAO organization, I just like to thank our platinum sponsors, Just Brazil and Albert Einstein Israeli Hospital, our gold sponsors, Logarithm, Legal Code, and PG Lawyers, and our silver sponsors, Urbano Vitalino Lawyers, Opsiblum Lawyers, and Oasis Open. Now, I'm sorry, guys, now you can begin your presentations. That's just bureaucracy, but let's begin it.
Thank you.
Thank you. Okay,
all right.
Can you see my screen now? Great.
Yes. Welcome, everyone, to the presentation of Lex Rosera, which is a work on transferring predictive models among different contexts, such as languages, jurisdictions, and legal domains. As you can see, this work is a joint effort of a sizable team of researchers in machine learning, computer science, and law, coming from many different institutions. And as I already said, this presentation will be delivered by Hannes and myself. So in this work, we investigate the task of segmenting adjudicatory decisions into parts, such as the background of the case, the analysis, or its outcome. We specifically identify the task that is general and fits different contexts. By that, I mean different types of decisions from different legal domains, even countries and legal systems, which also means the decisions can be in different languages. We use this task to evaluate the effectiveness of pre-trained multilingual embeddings to transfer a trained machine learning model across such contexts. We release the task type schema definition, the annotated dataset, as well as all the code we used in our experiments to the public.
So why are we doing this? Well, I think what you often see in machine learning is that the model is trained and evaluated on data with the same distribution. So there's some data set that is assembled, such as from legal cases, often, for example, from the same jurisdiction or in the same language. This is then split into a training and a test portion. The training portion is used to train the model, and the testing portion is used to evaluate the performance of the model. But this doesn't always tell us about how well the model will generalize. What happens if we give it a new unseen data set? Because the model might have learned some specific particularity of the data set it was trained on that will still work well when applied against this testing model, testing data set, but when it is used in practice, perhaps the data looks different and the model might just work very badly on this new data. So here we investigate whether it is possible to build models that generalize between different contexts. And as Jeremy mentioned, by context we mean different languages, different jurisdictions, and different legal domains. So we identify the task that is relevant across many such contexts. And the task that we chose was to segment legal decisions into different portions. First, the segment of the background, where the facts are introduced. Then the analysis, where a judge would discuss these facts and apply legal rules. And finally, the outcome, where it states the results of this. And here you can see a human annotated decision from the Czech Republic that has been annotated with these segments. But this kind of type schema works across many different contexts. So here, for example, is a decision of employment dispute from the United States that has also been annotated by a human with these same categories. So what we can do now is that we can take data from one context, train a model with this, and then evaluate how well it performs on data from another context. So for example, what we've done here is that we've taken a model that is trained exclusively on data from the Czech Republic. And then we've used that model to segment this decision from the United States. And here you see the results of this. So this is purely generated by a machine, these segments, that has never before seen any decision in English, and has never before seen a decision in labor law, but rather has been trained on decisions from the Czech Republic from various different courts. And as you can see, it still works pretty well. And I think this is pretty remarkable. What we're really doing here is that we train a model on data from the Czech Republic, and then we evaluate it against data from the United States that is never seen before, fully unseen data. But despite this, we achieve a weighted F1 score of 0.86. So that is one of the things we evaluate here. But we also look at what happens if we pool multiple such data sets together. So what if we add additional context to data from the Czech Republic and evaluate that against data from the United States? And what happens if we use all of our data set as a pool for training? Will that and include also data from the target context, so the United States in this case, will that further improve performance? I think this could have pretty interesting implications here. First, it could allow the creation of really robust and generalizable models. That is, models that you could deploy in a real-world scenario, and it would work across many data from with different distributions, different languages, and from different contexts. It could also allow the rapid adaptation of models to new contexts. You could start with a model that has already been trained and that works pretty well on your target context, and then fine-tune it a bit to make it work really well. That's probably much quicker than training it from scratch. And finally, it enables this international collaboration of researchers, since researchers can annotate their own data set and contribute to a common pool that is then useful to all the different researchers across many different countries.
All right, let us speak about the data set. So as already mentioned, the first step in creating the data set was a definition of the type schema. This definition is expressed in detailed annotation guidelines, and of course, these are also available in the project repository. The type schema includes types such as out of scope. So these are parts outside of the main document body. For example, metadata and editorial content, maybe endnotes, appendices, and such. Also headings. These are fairly straightforward. So for the purposes of our experiments here, we removed the out-of-scope content and headings, which only left us with background, analysis, and outcome. Background is the part where the court describes procedural history, relevant facts of the case, and so on. Analysis is the section that contains reasoning of the court, issue, maybe applicable law, and finally, outcome are the few sentences stating how the case was decided. It is worth mentioning that by removing headings from the texts, we have made this task more difficult. Right? There are some domains where headings are suggestive about the beginning of a certain part. However, this is not a general rule. And what we wanted to do is to make sure that the models we train will focus on the meaning of the text rather than on superficial cues, such as the presence of a heading. Reliance on such cues would have almost certainly resulted in models that are very brittle and would prevent a successful transfer among different contexts. Now, after learning the types definition and participating in the training, the authors split into 8 teams, where the goal of each team was to assemble a dataset of approximately 100 documents. The authors could create such dataset in whatever way they wanted. The only constraint really was that each sub-dataset needs to contain decision documents that are in the same language. The aim was to obtain collections of documents that would be quite different when compared to each other. We needed this in order to investigate the transfer capabilities of the multilingual embeddings. To give you a more precise idea of the differences among those subsets, let us look at some of them more closely. First of all, it's apparent that they come from different countries and the documents are very often written in different languages. For example, the German subset is a stratified sample from the federal jurisprudence database spanning all federal courts, such as civil, criminal, labor, administrative, and many more types of court. On the other hand, one of the USA subsets is a very specialized selection of federal district court decisions in employment law, mentioning the term motion for summary judgment, employee, and independent contractor. So a very, very narrowly specified domain. Overall, the dataset consists of 807 cases coming from 7 different countries that are written in 6 different languages. There are almost 90,000 sentences annotated with one of the types from the schema presented earlier. As already mentioned, the dataset, including the type schema definition, is available in a publicly accessible repository. To give you a bit more insight into the data we operate on in this work, let us look at this graph. First of all, notice that we did not use the out of scope and heading sentences in our experiments here. This reduces the size of the dataset from around 90,000 sentences to roughly 75,000. It is very apparent that there are some considerable differences among the parts of the dataset. For example, the French decisions are quite short when compared to others. But there are also some shared similarities. For all the datasets, it holds that the analysis sentences are the most numerous, followed by the background sentences. Finally, the outcome sentences are the most rare. Except the French subset, the number of outcome sentences is considerably lower than the number of sentences of the other 2 types. That is for the dataset, and let us move on to the models.
Right, so to perform this task of segmenting the decisions into different sections, we need to develop a machine learning model. And this is a high-level overview of how that model looks.
Hannes, I'm sorry, just to alert you, you have 4 more minutes to finish this presentation, and so we can open the questions, okay? Just so you know.
We started late, and it's...
Okay, so let's push more 7 minutes, okay?
Okay.
So at the bottom here, you see the case that is, first of all, split into different sentences. And each of these sentences using tools such as spaCy. And each of these sentences is then fed through an embedding model that is called LASER, language agnostic sentence representations, that embeds these sentences into an embedding space, a vector of 1024 dimensions. And the special thing about this representation is that it is language agnostic. So these embeddings, if the semantic content of the sentence is similar, they will be in a similar embedding space, close to each other, no matter the language. This is then fed to a gated recurrent unit bidirectional network, that then for each sentence outputs a label, such as the background, the analysis, and the outcome. And this is a bidirectional model. So in making these predictions, this model has access to the previous and also the following sentences and their embeddings. So then performed a number of experiments. We evaluated 3 different hypotheses, and what they differ in is what is used as training data, whether they're single or multiple data sets. And we always compare them against the baseline to make sure that the results are strong. And then we evaluate this by looking at an F1 score, and we do this, that is a harmonic mean between precision and recall. And we do this for 10 k-fold splits for each experiment to make sure that the results are regular. So let's start with the first hypothesis, that is the out-context experiment. So the question that we want to examine here is, can a model trained in a single context generalize to other contexts? So it's possible that a model can learn from one language or jurisdiction and so on, and be successfully applied in another context. So we saw this before, where we use one single context as training data, and then we test it against another context. And we move through the different contexts this way. First Czech Republic, and then France, and so on. And once we've done all of these, we will use a different context for training, such as the Czech Republic, and test this against another data set. And we compare this against a baseline of stratified random prediction, and that outputs a random prediction based on the distribution of the data. And here you can see the results. So to the left here is the context this is trained on, and to the right is the average F1 score, and we compare it against the rest of the data sets. So the baseline gets an F1 score of about 0.51, And all of our models actually gain an F1 score that's quite higher than this, between 0.60 and 0.70, and sometimes higher. So this seems to be able to learn something. And we've also seen that if data sets are similar, it seems to perform better, such as Canada and the United States. And we'll get back to this later, why this might be the case. And even the outcome section, that is much rarer than the other sections, is sometimes works to predict using this model. So from this, I think you can take away that the models are able to transfer knowledge between different contexts, despite having never seen this before and being completely different languages or domains. So next, let's look at the H2 experiment, the pooled out context experiment. So here, the question is, what if we add additional context to the training pool? Does this increase robustness? As in, does it make the performance better when applied on unseen data sets? So whereas before, we use a single context for training and try it against a target data set. Now we use this single context plus the other contexts that are not part of, that are not the target data set, and see how well this model performs. And then we move on. So for example, here we take France and then we exclude this from the training data and continue prediction. And as a baseline here, we use the best performing out context model per context. And I want to highlight that this is quite a competitive baseline, since as I mentioned before, some data sets are much closer together. For example, Canada and the United States perform very well across each other. And that means, of course, that if a model is trained on Canada, this will be the best performing out context model per context for the United States. Whereas our model has many more different data sets that it needs to abstract from and learn this to apply to this new context. And here you can see the results. So this row is for the baseline, and here we have our model. And as you can see, in 7 out of 8 cases, our model matches or improves on this baseline. And the results, as you can see, are pretty high, usually over 0.80 and sometimes even over 0.90. And remember, this is on really unseen data. So this is something that could potentially be useful when applied in practice and being used on a completely previously unseen domain. So I think from this we can take away that training on a pool of data sets leads to more robust models, and it leads to better adaptation to unseen contexts. And finally, we have the pooled within context experiment. So what's happening here, that the question is, does combining in-context data with out-context data improve performance? So whereas before we excluded this training data, now we add this data as well. So we use all the different contexts for training and then evaluate it against a single test context. Of course, we don't use the same data. We use different folds here so that it's still never seen the testing data, but it has seen data from that context. And then we move through to use this to predict the different target contexts. And as baseline here, we use in-context models. So that is a model that has only been trained on the target context. And again, I want to highlight that this is a super competitive baseline. This is seeing the data that will be by far the most similar to the target context. And this means that the model trained on only this data should have a really good opportunity to learn the distribution there and to do that prediction. Whereas our model, of course, has 8 different data sets that it needs to learn from and extract from. So it is quite difficult to get this baseline. But despite this, in 6 out of 8 cases, our model outperforms this baseline. And again, the results are very high, often over 0.80 and often even over 0.90. So I think from this we can take away that training on in-context data pooled with out-context data does improve performance when compared against this single models trained on a single target context. So the model does seem to be able somehow to abstract from these different data sets and take the lessons to build a stronger model.
All right, let us look at some of the findings more closely. So the results from testing hypothesis 1 and hypothesis 2 strongly suggest that multilingual embeddings focus on the semantics of the sentences rather than superficial linguistic features. This is extremely important for a work like this one. It is very important that the models focus on the semantics and avoid fitting the context-specific idiosyncrasies, even though they could be useful within that context. Moving on, we observed that some of the contexts appear to be more related amongst themselves than to other contexts. In order to get some additional insight into this phenomenon, we projected full documents into a shared semantic space. Using PCA to reduce the dimensionality to just 2, we obtained this visualization where each dot represents a single document. The color encodes membership of a document in a specific context. You can see that both the USA subsets occupy virtually the same semantic space. This makes a lot of sense if you consider that the documents are written in the same language, they come from the same tradition. On top of that, both subsets are focused on employment law. German subset occupies the space in the middle, and it also appears to be a bit more dispersed than the other ones. This is likely due to the fact that it is the most general data set, not focusing on a specific topic. Of course, this is expected, and it provides grounds for future work. In this work, we did not factor the context relatedness in our experiments at all. Another interesting observation relates to structural differences in the documents. We noticed that German and Polish models struggle in predicting the outcomes for other subsets and the other way around. This is explained by structural differences in the documents. Whereas the German and Polish documents report the outcomes that are depicted in green at the beginning of the decisions, the documents from other subsets tend to place these towards the end. However, it is promising that the models that have access to data with both these patterns were able to acquire them both and apply them rather successfully. To conclude, we observed that the models utilizing multilingual embeddings manifested good generalization capabilities. It appears that pooling multiple contexts together results in improved robustness and performance of the models, and it helps even when in-domain data is available. It was an extremely rewarding experience to identify a task that was relevant for researchers with different interests and was applicable in wildly different contexts. And we are really looking forward to what comes next and how the dataset and the code we released is going to be used by this community. And of course, we also have some ideas of our own. While the dataset is sizable, it would certainly benefit from expanding it with more documents from more different contexts. We use the data in the most straightforward way here to segment the documents into parts with different function. However, this could be a useful step in many applications focused on, for example, information retrieval or summarization. In our experiments, we simply pull the data from different contexts together. Using more sophisticated approaches would be a reasonable way how to improve on this work. Finally, we also anticipate that resources resulting from this type of work could be useful for gaining insights into differences and similarities among the different contexts, akin to the structural analysis of the documents performed here. All right, that's all from us, and we are looking forward to your questions.
Thank you, Jaromir. Thank you, Hans. I'm sorry again for the delay. I really liked your presentation. Actually, people have 5 minutes to ask some questions, but I have one. I like to know about regarding the transference of these models on arbitral proceedings. Can we apply or use this model itself in such proceedings?
I mean, the current model was trained on judicial proceeding from a really wide variety, and there's some judgments in there from courts, there's some tribunals and so on. So it is really a wide range of data. I think this does suggest that this could be something that could be useful across such data as well. And if you look at the paper, it seems that even though there are completely different instances involved, different types of instances, it does seem to generalize quite well. So if this kind of schema does make sense to apply on that kind of data, I think it's definitely something that would be feasible. And otherwise, I mean, as you mentioned, this is just one type of schema, but there could certainly be others that could be very useful, no matter what type of data we're looking at.
To specify this answer a little bit further, so the multilingual embeddings that we use, they support almost 200 languages, and they are supposed to work to a certain extent even on languages that they were not trained on if the languages come from the same family as the languages that this was trained on. So theoretically, we could take document in almost any reasonable language and applied it. And if the task makes sense, meaning that it's a judicial document that kind of follows this similar structure that we have here, it would be applicable there.
Very well, very clever. Thank you. We have another question. Can you explain embeddings that are language agnostic? Is heterogeneous data being homogenized, which could explain transfer learning?
Yeah, certainly. I mean, I think that's one of the key things here about this model is really the idea that it does the translation for us, or we don't even have to care about translation, because what it does is it takes these sentences, no matter the language, and it encodes this into this shared semantic space. And in this space, and we've seen this work really well, where like two sentences that are, say, in Czech or in German or in English, they will always end up very closely if the meaning behind them is very similar. I think that's one of the really powerful methods of this new deep learning paradigm, where we can download a model like this that has been pre-trained on almost 100 languages and apply this on our own data and get something that is able to generalize so well across different languages.
Yeah, and again, I mean, just to make the point, so the translation does not really happen. Like you supply the sentence in almost any language, the sentence is projected onto a vector, and sentences coming from different languages, if the meaning is close, the vectors will also be close. That's how this works.
Okay. We have one last question. Do you think the results could be improved when using your model as an ensemble with another model that relies on the structural information, like headlinks?
I mean, definitely, there is a lot of space for improvement. So in our work, we did not really drive towards like the best possible performance. Our goal really was to evaluate the capabilities of the multilingual embeddings to see if this really works in a legal context, in the particular task that we were evaluating. But what is being suggested here is definitely one of the very promising paths towards improving the performance, and we also see many other.
And the data is there, so if someone wants to do this, we really encourage people to try this out and see how that would work. It would be really interesting.
Okay, guys. So I think that's it for questions. Yeah, we don't have more questions. So thank you again for a brilliant presentation. Now I'd like to ask Nicholas to have his presentation. Nicholas is going to present a short paper. So he has 15 minutes, 10 minutes for presentation and 5 minutes for questions. The name of his presentation of his work is a French plummet's description, data to text data set for natural language generation. Nicholas, if you could present yourself, please, and you may begin your presentation. Thank you.
Absolutely. Thank you, Gabriel. I bet that you can see my presentation clearly now, right? All right. Hi, everyone. My name is Nicholas, and I'm a PhD student in Quebec City, Canada, at Laval University. And hopefully I will finish my PhD soon enough in the next year. And today I'm presenting a project that we've been working on lately, which is Plume to Text. And as Gabriel told it, it's a French primitives descriptions, data to text data set for natural language generation. So I'll begin by introducing the team behind this project. So there's myself, and I work closely with Eve Gaumont, who is a master's student in Faculty of Law, as well as Luc Lamontagne, my supervisor, and Pierre-Luc Desiel, who is the supervisor of Eve Gaumont in the Faculty of Law. So I'll begin by introducing the underlying task that we are trying to solve with this new data set that we are introducing today. So in 2020 at INLG, the International Conference on Natural Language Generation, we introduced the task of generating intelligible primitives. And by primitive, these are like, I would say, docket files, similar to docket files. These we want to generate intelligible primitive descriptions. And in this paper, we first introduce the task and the first baseline model, as I will introduce shortly. So just to give you a sense of what we're trying to do, we have on the left here the first page of a docket file, a primitive, which contains different information about the accusation, and this is a fake case, obviously. So we have the accused. We also have a couple of charges, references to the Criminal Code of Canada, as well as the pleas. Sometimes we have a sentence, the decision, and so on. So these documents are kind of cryptic, and they contain several abbreviations. and they are supposed to be widely accessible to the Canadian citizens, either to be in the context, in the educational context, or in some cases when citizens want to represent themselves, they are supposed to be to have access to this kind of document. However, there is a problem in an intelligibility problem with this document, being that, well, as I said, it contains a lot of references to the criminal code and a lot of abbreviations. So the goal of this project is to take into input this document and generate a short description, or well, translate this document into a more digestible piece of text, essentially. So this is why we frame this problem into a data to text. We extract the meaningful information from the docket file and generate some description out of it. So the first baseline model that we introduce is based on a rule-based generator. So we first scan through the docket file, extract the different parts, and normalize, extract the structure from this denormalized documents. And then giving some rules and the criminal code of Canada, we then generate a short summary of this, or short the description of this documents. However, we had a couple of generalization problem with this model, because the rules have been extracted first by a legal expert, but from a subset of the docket file. So, and a rule-based language generator may be hard to maintain and even to build if you gotta have a sense of how the legal system works, what abbreviations are, and things like that. So we hopefully want to solve this problem or replace this rule-based generator by some deep learning sequence-to-sequence generators. And by hopefully, I mean, well, we are actually testing this. And this morning I presented a model that we are actively working on, which is Criminal Bar. And it's a pre-trained language model that has been trained on thousands of judgments from the Criminal Court of Canada. So it grasped essentially some semantics from these legal documents. But in order to train such a model, we need a data set to train this. And this is why we build this data set. So we wanted to create a data set with primitives, docket files, and their associated descriptions in order to train such a statistical model. And this is why we introduce primitive text. So I'll present how we created this data set, and I'll first introduce the court judgments, as well as the annotation tool that we developed for this, and then the outcome, which is primitive text, and just a really simple example from the data set. So court judgments are, to some extent, a lengthy description of the primitives. So we have several pages, and within these pages, we have, at some places, references to the accusations, the verdicts, the pleas, and the sentences. So we can create a mapping between the different sections of the primitive with, for example, the paragraphs within the associated judgments. So the idea is to create these association for every accusation. So in this work, we focus mainly on the accusations and the decisions and the pleas, but the annotation methodology and tool generalizes to any other parts of the primitive. So I'll introduce the annotation tool that we developed for the creation of this data set. So the annotator, which were basically me or Ev, add an interface where on the left side we have the set of charges that are within the primitive. And on the right side, we have every paragraphs or sections from the judgment, the document. And so what we did is that we didn't want to skim through the whole document since it may be hundreds of paragraphs.
Excuse me, Nicholas, just to alert you, we have 3 more minutes, okay?
Okay, perfect.
Oh.
I'll fast forward just a little. So we created classifiers in order to put at the top the relevant paragraphs and to easily associate sections from the primitive with the relevant paragraphs that we wanted to keep. And then the annotator just has to save it. And then there's another interface where we label to which part of the accusation, if it's the charge, if it's the plea or the decision, for example, this paragraph is referring to. And again, here we are using really simple text classifier to pre-annotate these sections, and then the annotator, if the pre-annotation was not correct, we then fix this annotation and then submit and save this. So these really simple textual classifiers accelerate the annotation process a lot, reducing to around 2 minutes per document. And originally, we were talking about 10 or 15 minutes, I think, per documents. And we essentially reduced the number of clicks and scrolling time for the creation of this data set. So one thing I just want to quickly mention is that we are decontextualizing plume to text in the sense that we are removing any sensible information from this data set, because we really want, we don't want any private information to leak from plume to text. So we first apply an automatic depersonalization using name entity recognition models by removing names, places, organizations, and dates. We then went through the thousands of examples manually to replace the names, places, and organizations that the NER model may have missed. And we also removed contextual information specific to the crime that has been perpetrated. For example, assault his neighbor, for example, we would remove this. We also remove anything that is related to gender and numbers, and information describing the victims. Obviously, we would remove a woman, for example, in this piece of text. So this is a really simple example extracted from this data set. So we have 2 charges here from section 320.14(1)(a) from the criminal code and B, and we also have a verdict. And this is the associated piece of text, associated description of these sections of the primitives. So this is exactly how it is represented into the JSON file that we release. So we have around 2,400 pairs of charges containing also the verdict or the pleading associated with a textual description. So the data set is available here. And if you have any questions or any comments, feel free to reach out either during the question time and or on any social media. So just to finish off, we are still improving this data set by adding a little more examples. And now we are actively working on training a statistical generator on this data set. And I would like to thank everybody for listening, and I'm happy to take on the questions.
Okay, thank you, Nicholas. I actually enjoyed the presentation. I am curious for these future updates. I'd just like to ask you a question. What do you believe to be the biggest issues when facing the future proceedings for the future works?
Actually, what we developed an natural language generation evaluation metric, because in a legal case like this, you really don't want a statistical generator to generate unfactual piece of text. You really want it to be aligned with the original primitives. You don't, because these kind of models are known to hallucinate some things. So what we are developing is a evaluation metric. However, there are still some concerns because we don't want to generate some texts like that won't be factual. And so we always consider falling back to the rule-based model, which will be really factual and will reflect the original docket file. But I mean, this is research, and we want to push as far as we can this statistical generation. But this is the main concern that we have, actually.
Very well, very well. We are still waiting on questions, but yeah, we have not received new questions here. Well, if you want to use this moment to maybe comment on something, or use it a final time to do some last comments, maybe.
Well, I would like to thank Eve and Pierre-Luc and my supervisor Luc, who worked closely with me on this project, and also the SOCIJ, which is the Société Québécoise d'Information Juridique here in Quebec City, who provided us with the data set and the task, actually. So we are closely working with them, and hopefully this tool is going to help a lot of Canadian or Quebec citizens in order to, well, our main goal is to provide a layer of access to the judicial system. So hopefully this is going to be used by the government, because we really believe that it's going to be useful for not only the lawyers, but also people that are facing the judicial system.
Very well, Nicholas. Thank you for your presentation. Now I'd like to call Adriana Unger for her presentation on the theme of the name of her paper is Process Mining Enabled Jury Metrics, an analysis of a Brazilian court's judicial performance in the business law processing. Adriana, you have 10 minutes to your presentations, and then we'll finish with 5 minutes for Q&A. And present yourself, please, and start your presentation.
Okay, hi, Gabriel. I am Adriana Unger. I am a PhD student from University of São Paulo in Information Systems. And I will share my screen here. Can you see?
Yes.
Okay. So hello, everyone. I will present the paper Process Mining Enabled Jury Metrics, which is a joint research between the Process Mining Research Group at University of São Paulo and the Brazilian Jury Metrics Association. In this paper, we present a proof of concept for the application of process mining to the analysis of judicial performance of the Court of Justice of the State of São Paulo in Brazil, considering the processing of lawsuits in the business law. Well, improving judicial performance is increasingly relevant to guarantee access to justice. If we consider the current judicial setting, we can see that high litigation rates challenge judicial systems all over the world. Litigation rate is the ratio of new lawsuits each year to the population. In Brazil, we have high litigation rates combined to high volume of ongoing lawsuits, resulting in a heavy workload in the judiciary. At the same time, we notice an increasing use of technology to support lawsuit processing. Not only electronic lawsuits emerged, but also management information systems that record every procedural act performed inside the courts. The Court of Justice of São Paulo, which is the subject of our study, is considered the largest court in the world, with over 19 million ongoing lawsuits. All lawsuits in this court are born digital since 2015 and are managed by the eSage Justice Automation System. Concerning judicial performance, it's a field of study dedicated to evaluating performance of judicial systems. And we remark that most judicial performance studies focus on global measure of court performance or comparison between courts. As an example, we can see the values of IPC-JUS index for each Brazilian state court, IPCJUS is the Comparative Justice Productivity Index, which summarizes and compares the productivity and relative efficiency of courts in Brazil. Such index guides the measurement of judicial performance, but it is not so helpful to diagnose lawsuit processing issues or to guide improvement actions. Another important field of study is jurymetrics, which is the application of statistics to law. Jurymetrics is not new, but is becoming more relevant due to the increasing availability of judicial data. Many jurymetrics techniques are used to improve the practice of law, including judicial performance. Here, we can see a recent study from the Brazilian Jurymetrics Association on the specialization of courts of law. However, these studies are based on a data-oriented perspective. Considering lawsuit processing, we see an opportunity for jurymetrics to consider the procedural nature of lawsuits. In this sense, process mining offers an innovative approach to analyze judicial data from a process-oriented perspective. Process mining is a new field of study that enables event logs to be mined into process models that help to understand operational processes in organizations. In our work, basic elements of the event log were mapped to their counterparts in the procedural law domain. Each lawsuit represents a case in process mining, and every time a lawsuit progress occurs, this movement is registered in the court management system. Each movement corresponds to an activity of the process, and the date when it is occurred is considered as the activity timestamp. Process discovery algorithms build process maps from event logs, which in our work reveal the sequence of activities that were performed during the processing of lawsuits inside the court. Process analysis can then be applied to support performance improvement of the process, which includes identifying bottlenecks, reducing costs, lead times, and error rates. In our study, we show the application of process mining to analyze judicial performance based on an event log created from a lawsuit dataset, which was extracted from the court information system. Well, regarding our research methods, we adapted a process mining project methodology to the analysis of lawsuit processing, and the study was restricted to business law and considered the complete log of almost 5,000 lawsuits from the Court of Justice of São Paulo, including additional case attributes for process analysis. We used the Brazilian process mining tool Everflow to perform process mining of this event log. As a result, we performed analysis based on 4 perspectives. The first one is the control flow perspective, which generated the process map for the lawsuits that we analyzed, including the calculation of the main process metrics. These process maps also highlights the most frequent activities and transitions of the process. And the view is user interactive so that activities, transitions, and the time interval can be selected and filtered for drill down analysis. The complexity and procedural viscosity of lawsuits in business law was confirmed by the average rate of more than 55 movements per lawsuit and the average lawsuit duration of almost 1 year. The process map can also be presented using the average duration matrix, which leads us to the time perspective of process mining. In this case, highlights in the process model review bottlenecks activities and the slow transitions during the processing of lawsuits. As an example, a slow transition was found between issued publication certificate movement and suspension of the term movement, with duration of 21 days and affecting more than 40% of lawsuits in the dataset. This bottleneck is possibly due to litigant issues, such as lack of required documentation, and causes an increase of almost 80% in the lawsuit duration. Concerning the reserves perspective, we consider process analysis based on the ruling judge of each lawsuit. In our dataset, efficiency metrics were similar among all the judges involved, suggesting that the root causes of inefficiencies in the processing of business law are not related to the judge. Since we have a case attribute in our dataset that indicates whether each lawsuit is digital or not, in the case perspective, we performed a comparative analysis of on-paper and digital lawsuits. Surprisingly, we found that on-paper lawsuits are faster than the digital ones. We raised some hypotheses to explain this. One of them, considering that the main process bottlenecks in business law are related to internal activities that are independent on the digital nature of the lawsuits, hiding other inefficiencies usually associated to on-paper lawsuits. Using process mining, it's possible to compare not only the main process metrics, but the detailed flow in each situation. As a conclusion, we argue that process mining offers benefits of a process-oriented approach to analyze judicial data for performance diagnostics, providing insights into the root causes of inefficiencies so that actions to resolve them can be defined. We also prospect the use of process mining to provide online dashboards for continuous judicial performance monitoring. We would like to kindly thank Kleber Stroh from the Everflow company for supporting this research. And I would like to thank everyone that's here today. It's an honor for me to present this work, being one of the few Brazilian researchers in this ICAO conference. So, muito obrigada.
Thank you, Adriana, for your presentation. The time for questions is now, it's open. I would like to ask a question, actually. Could you, currently, as you said, in Brazil, one of the biggest discussions regards the legal uncertainty by the judicial branch, mainly in superior courts. But how can we separate those controversial decisions and still prevent the bias from that mechanical separation to appear in the results? Thank you so much.
Well, in this work, we didn't focus on solving a legal problem during the processing of lawsuits. We actually wanted to show that process mining can enable a lot of analyses that are really difficult to do today. And I think that I don't know exactly we didn't study the superior courts and the lawsuit processing in these courts, but I'm pretty sure that if you analyze each activity of the processing of lawsuits in these courts, and if you apply the process mining algorithms to group and to identify bottlenecks and things like that, I'm sure that you can identify lots of room for improvement there.
Okay. We don't have any more questions for now. People, if you wish to ask something, feel free to do so. While we wait, Adriana, if you could maybe say a few words, comment on something you'd like to comment, or thank someone, I don't know.
Okay, I would like to thank my supervisors, Marcelo Fantinato and Sarah Jane Perez from University of São Paulo. I would like to thank my colleague in this paper, José Francisco. And I would like to thank very much Júlio Trecente and Renata from the Brazilian Geometrics Association. This research would not be possible with the collaboration of everyone.
Okay. Well, Adriana, thank you for presentation. We have not received any more questions. We can wait a little bit on that. So if anybody still have questions, now it's the time.
Well, I might say that if I will be on the Gather Town platform, so if anybody has some more questions or need to know want to know more about process mining, I'll be there.
Yeah, actually, this is a very good reminder, Adriana. We have Gather Town people. There's a social platform on which we do some interactions. You can talk to people who has presented papers. You can talk to our sponsors too. You can talk to us on the organization. Is the method we found to be nearer from you during this pandemic scenario. So if you can at some time join there, the room is always open. So during the breaks, we will be there to talk to you, and people may join Gather Town. So I'd like to show everyone how it's done. How can you enter Gather Town? So could maybe I'll share my screen here since we have some time left. I'll share my screen here. Okay, here. So I believe you can see my screen right here, right? So what we do is we click here on Gather Town, and then you'll be sent to this page. And what you need to do is you can just click the link, unfortunately, but you can copy it and then paste it on your browser. Okay, I'll show you. And then you can access, you go continue on browser, join the gathering. You can have your avatar, you can change your avatar, and then you can walk around. And when you get near other avatars, other people, you can talk to them just like in real life. So we have some games in here. Oh my God, I'm not going to talk to anybody now. We have some games here. In here you can chat, have some doubts. We have our sponsor stands here. They are available all the time or most of the time to have some to answer questions. And well, I just wanted to show you how we are doing things here on Gather Town, and ask you to go on and invite you to go on there and have some fun there, actually. Thank you again. In name of the organization, the IKL organization, I'd like to thank all the attendees and all the paper presenters in this panel and all the others. And once again, thank our sponsors for all the help. They have been very, very important to us to make this possible. And I'll see you tomorrow. See you all tomorrow. I hope you